All right. Well, let's get started. Good morning, everyone. My name is Elizabeth Lawn. I am a lawyer at LM Law Group. And with me today, we have two other lawyers who work in the area of refugee law, and they're experts in this area. We have Katan Boe-Mitchell and Aaron Levitsky. All right. And today, what we are going to be talking about is a brand new bill that was just recently passed and is in Canadian law right now, the Bill C12. And really, what this law does is it really changes the landscape of refugee claims in Canada. And so today, we're going to talk about that. So let's get started.
Okay, good afternoon, everyone. My name is Katan, and I'm here with Aaron, as Liz said, and we're going to talk about how Bill C12 impacts refugee claimants. So broadly, we're going to talk about who does the law impact. There's sort of two subtopics we want to talk about. We'll spend more time on the timing and entry of claims because this is a big change to the system. And we'll spend a more brief time at the end talking about a certain subsection of people who will be impacted, which is claimants entering from the United States. But we'll get started talking about who does the law. We'll start talking about how to know if you're impacted or if you might be impacted if you make a refugee claim. So, sorry, I'm working the slides and there we go. Okay, so first we'll talk about the timing and entry of claims, as I said, and Aaron will get us started going through this decision tree that should help us figure out if you or someone you know is impacted by C12.
Okay, thank you, and good afternoon, everyone. So, under this new legislation, not everyone is impacted, but we have to, for a lot of people, what determines whether they're impacted is the timing of their entry to Canada and the timing of their claim. Okay, so the only people who are ineligible to make a claim under this new law are those that meet in terms of the timing. So, separate from what Catan mentioned in terms of entry from the US, um, this is for individuals who meet all three criteria on the screen here. So, I'll walk you through this decision tree. And then after that, we'll go through some examples to help you really solidify your understanding of how this works. But basically, the first question that you would want to ask is, did you or the person that you're thinking about that you might know enter Canada after June 24th, 2020? If the answer is no, then C12 does not apply to you in terms of being ineligible based on the timing of your claim. If the answer is yes, then you would have to ask the second question, which is, has more than 1 year passed since your entry to Canada after June 24th, 2020? If the answer is no, then again, C12 does not apply. But if the answer is yes, then you have to ask the third question, which is, did you submit a refugee claim on or after June 3rd, 2025? I know it's a lot of dates to remember. It can be kind of tricky, but the key thing to remember here is that you would need all three of these to be true in order to be ineligible to make a claim.
So, Aaron, what does it mean to have 1 year passed since I entered Canada? Do I have to have been in Canada for a year?
That's a great question. It's not very intuitive actually, but the way that this law works is that the clock starts ticking from your first entry after June 24th, 2020, and it doesn't stop even after you leave Canada. So, say you came to Canada after June 24th, 2020, but you only stayed for a single day, and now you want to come back years later. The clock has actually been running that whole time in the background, whether you spent that time in Canada or not. And again, we'll go over some examples shortly to help clarify that.
And does this apply to everyone?
That's also a good question. We are hearing that there's an exemption that will be created in the regulations for unaccompanied minors. That's the only exemption that we've heard so far that's going to be carved out, but it is always possible that other exemptions are created in the future.
Okay,
So,
so
Erin,
we'll take, oh, sorry,
Mhm.
Liz, go ahead.
no, no, you go ahead, Ketan.
I was just going to take us to the next slide. So,
Oh, well, I just have a question. So basically, for the third one, if I have not yet submitted a refugee claim, but am thinking of submitting a refugee claim after June 3rd, like now, right, or in the
Mhm.
future, then this applies if the first two also applies.
That's correct.
Okay,
Yes.
great.
okay, so as we said, there's a lot of different dates. So we'll go through some examples to hopefully clarify the dates. So the first example is a bit similar to the one that Aaron used answering my questions, but if someone entered Canada on June 26th, 2020, and they left Canada the very next day on June 27th, 2020, and they wanted to return to Canada to make a claim tomorrow, they would still be ineligible. And that is because of the clock that Aaron mentioned. So the clock started ticking because this entry is after June 24th, 2020. So even though I was actually only physically, or this person hypothetically was only physically in Canada for one day, that doesn't matter because the clock started already.
Okay, so for the second example, this would be an individual who enters Canada on June 20th, 2020, and left Canada on June 22nd, 2020. So just note that both of those days fall before the June 24th, 2020 date. And then this person wants to return to Canada now to make a claim. That person would be eligible because the clock only starts running from the first entry after June 24th, 2020.
And in the third example, it's sort of the most simple example of this, but this person has entered Canada December 1st, 2022. They haven't left. And in this example, we're saying they haven't already started a claim. So they're now thinking about making a claim now. They're ineligible because they've had to gone through the decision tree on the other slide and they've hit yes for every answer.
Okay. On the flip side to that one, example four is an individual who has entered Canada on January 5th, 2017, and has never left. This person is still eligible. It seems maybe counterintuitive, but because the clock only starts ticking after someone's first entry after June 24th, 2020, it doesn't matter that this person has been in Canada for 9 years at this point. They would still be eligible to make a claim.
And in the last example, if someone entered Canada again, we're using the June 26th, 2020, and then they left June 27th, 2020, they returned to Canada and made a claim on June 4th, 2025. They are ineligible. And that is because the clock started ticking June 26th, and then when they entered Canada and made their claim, they made their claim after the June 3rd, 2025 date. So they're ineligible. They had claimed May 21st, 2025, they would be eligible. But it's all about these dates. So hopefully those examples kind of clarify how all these dates interact with each other and how they might make people ineligible for claims. So we'll go on to what does it mean to be ineligible? So if you are now you figured out, okay, I'm ineligible, what can I do? Or how does this impact someone I'm helping? What this means is that usually when you make a refugee claim, you are referred to the Refugee Protection Division of the Immigration and Refugee Board. Um, and in that case, you go forward and you get a hearing and you talk to a board member about your situation. On the next slide, Erin will go through some key differences between a refugee claim and a pre-removal risk assessment, which is what we're going to talk about here. So if you're ineligible, you don't get that refugee claim. Instead, you still have your risk assessed, but it's assessed through a different process. And this is the pre-removal risk assessment process. And so, um, unlike a refugee claim where you can decide when you start your claim by submitting your claim. A pre-removal risk assessment is something that is served to you by the Canada Border Services Agency, CBSA. So only CBSA can start this process. So right now, it's because it's this transition period where they've just introduced this new law, and there's a lot of uncertainty about how the processes are going to work. But the only way right now to start the process, if you haven't made a claim already, is you actually still have to make a refugee claim. You make the refugee claim, you will be found ineligible, and then you will be someone who is in this situation where you're ineligible for a refugee claim, but the government is aware that you're eligible for a PRA. But you can't actually get the PRA and start the process until it's served to you. So Erin will take you through some of the key differences between the refugee claim and the PRA.
Okay, so the PRA and the refugee claim, they do actually look at the same risk factors, but it's the processes that can be quite different. So the PRA is a paper-based application. Everything is done in writing, and there's no right to an oral hearing in most cases. That's quite different from the refugee claim, where there is an oral hearing. And because of that, evidence becomes very, very important in a PRA application because you don't have the chance to talk about your case and your situation. The timelines for PRAs are also very fast. So forms are required 15 days after being served the PRA or the PRA being initiated by CBSA. And then documents are due and submissions are due another 15 days after that. Because of these very fast timelines, if if someone knows that a PRA is at all a possibility down the line, they really want to be thinking about keeping records and having evidence on hand to be able to provide to a lawyer quickly so that they can put those submissions together. There's also one of the other major differences is there is no appeal to a tribunal with a PRA. Whereas with a refugee claim, you could appeal to the Refugee Appeal Division of the Immigration and Refugee Board. With a PRA, the only way to fight a refusal is through the judicial review process at federal court. And while that process is ongoing, there is no right to automatically be allowed to stay in Canada.
So how long will it take to get a PRA if I'm found ineligible for my refugee claim?
Right. So this could be confusing because I did mention that the timelines are very quick after the PRA is initiated by CBSA, but it can actually still take quite a long time for CBSA to start that clock and to initiate the PRA. It could take quite a while. It's different for everyone, but especially with this new law, with so many more people being ineligible to make a refugee claim and then therefore required to make a PRA, we are expecting that these could take quite a while and people could be sitting and waiting for a while.
Okay. So the next thing we're going to talk about is, does everyone get a PRA? And so the answer to this is, in some ways, yes. Before you're removed from Canada, you will get access to a PRA. However, PRAs are meant to be the last thing that happens before you're removed. That's right in the name, pre-removal risk. And so there are certain people who won't be removed to Canada, won't be removed from Canada in unless there's exceptional circumstances in their particular case. But generally, people from countries that Canada has deemed unsafe to remove people to won't be removed. So they'll be stuck in sort of a limbo. And so they're not eligible to make the refugee claim, but also CBSA is not going to initiate their PRA because CBSA knows that they can't remove them after they do the PRA. So they just are left in limbo, as I said. So the countries that they're on the slide, and you can see there's administrative deferral of removal countries and temporary suspension of removal countries. And even though for the second one, temporary is in the name, these countries are actually more set. So Afghanistan, DRC, and Iraq have been TSR countries for a very long time. And they could be removed, but we don't have any reason to believe that they're likely to be removed. So if you're from one of those countries, you might be facing an extended period of limbo. Similarly, ADR countries, as we call them, uh, can change more frequently. So some countries, like Somalia. So it's certain regions in Somalia, but because Mogadishu is on the list and that's where planes fly into, people aren't really in practice being removed to Somalia. So Somalia has been on that list for a long time. Ukraine similarly has been on the list since the beginning of the war in Ukraine. However, some of these countries, such as the UAE, Kuwait, Bahrain, and Qatar, are very newly added to this list, and we don't really know how long they'll stay on there. So, if you're someone who's impacted by your home country, um, being on the ADR list, you might want to talk to a lawyer about what that means for you. And some of these countries, we might expect to see them no longer on the ADR list. For example, last year, Lebanon briefly entered the ADR list, and then about 3 months later, it was taken off again because the list is responding to crises and circumstances on the ground. So, those are people who will not get access to a PRA. So, as I mentioned, there's a period of limbo. And on our next slide, there's some strategy suggestions about what to do if you're potentially going to face an extended period of limbo. Okay, so if you're someone who is, say, from Afghanistan and you've been found or you know you will be found ineligible to make a refugee claim, you could think about submitting an application called a humanitarian and compassionate um, application, which can be submitted and it can be in process. And then if something happens and suddenly you are PRA eligible, the PRA and the H&C can concurrently be processed. Um, and so you can kind of have this other application ongoing as you are in this period of limbo and hopefully be able to regularize your status through an H&C since you're not going to be served PRA. Um, and
Um, oh, go ahead.
no, no.
Oh, I just had a question. Do officers assessing agencies and PRAs look at the same factors?
So the question of whether I should do a refugee claim and or an H&C is a question that there's always lots of discussion about, depending on a person's circumstances. But with an H&C and a PRA, essentially, no, they don't look at the same factors because the PRA, like a refugee claim, is assessing risk. An officer is going to ask if you face forward-looking risk in your home country, if you've experienced persecution. Whereas with an H&C, an officer will be looking at your establishment in Canada, the best interest of any child impacted, and also hardship. So in the hardship section, if you're someone who is eligible for a PRA and you're not being served it, but you have risk or things that you fear about returning to your home country, that can be addressed with a different framing in the hardship section. So could be hardship due to being a member of an ethnic minority in Afghanistan, for example. That could also be a refugee claim or a PRA if you're eligible, but that can be looked at in a different lens through an agency. And yeah, as I said, if you are wondering about doing an agency or if you have a strong agency while you're waiting for a PRA, definitely something you would want to talk to us or another lawyer about. Okay, so Erin's going to take us through another strategy slide. So I'll let you take it away, Erin.
Yes. So we recognize that with this new legislation, there are many people in Canada currently with valid temporary status, but who would also face persecution or risk back home. And now the wheels might be turning, and you're thinking, should I rush to make a refugee claim before the 1 year passes and I'm ineligible to make a claim as a result of the new law? One thing that I cannot stress enough is that this is a very important decision to make that has significant consequences that really need to be considered carefully. Um, this is not an exhaustive list by any means, but some examples of these consequences include the fact that you get a departure order when you make a refugee claim, which comes into force if the claim is refused. Also, the fact that temporary status is typically canceled when you make a refugee claim. So while you can still later, as a claimant, you can obtain a work permit or a study permit, the fact that your previous status was canceled can have long-term implications that you should discuss with a lawyer. Also, if you lose a refugee claim, it can be very hard to stay in or return to Canada in the future. And then there are some other things to think about in terms of other pathways to permanent residence, which is that one of them is that making a claim, a refugee claim, makes you ineligible for provincial nominee programs. And another is that work experience gained while making a refugee claim does not count for Canadian experience class for the purposes of express entry. So it's very important to talk through these options with a lawyer before making a decision about how to go forward.
Um, and Aaron, some of these consequences, people say, well, I'm going to make a refugee claim so I can get a work permit. What kind of work permit is that when they get a work permit?
Yeah, so the work permit would be a refugee claimant work permit. So it doesn't actually confer temporary resident status. It just authorizes the person to work while they're in Canada.
And so when you get a work permit and you have made a refugee claim, even if you're deemed ineligible, just so you can get a PRA, you essentially tell the government that you are afraid to go back. And when you're trying to apply for a work permit or study permit or visa, even if you withdraw the application, even if you later, leave the country, it is very, very difficult for you to get another document to you that actually gives you temporary status. Um, Also, if you have made a successful refugee claim and you decide later on, maybe, the country conditions are better, right? And you want to go back to visit your country or visit your family, even if you have permanent residence or even citizenship, you can still have your status taken away if you gained your status through a refugee claim. Okay. So before you guys undertake this step, Make sure you speak to a very experienced lawyer, who specializes in this area, because it will, as Aaron said, have a very dire consequence for your future. Either way, whether or not you are successful or not successful.
Erin, I have another question. I understand there's a new public policy. So if my claim is found ineligible, will my work permit be canceled if I already have one?
No, so that's exactly what the policy allows people to get around. So they announced this policy right around the time that the new law came into force, and it allows people to keep working on their current work permit, even if their claim has been found ineligible under this law.
So if you've made a refugee claim previously and you're retroactively facing an ineligibility finding, but you already have your refugee work permit, you can keep working on that. And if you are in that situation, you want to apply for a new work permit before that one expires, so you can keep working with implied status. Okay, so we're going to briefly talk about claimants entering from the United States. So this impacts people entering from the United States because of the agreement between Canada and the US, which is called the Safe Third Country Agreement. And essentially, what that agreement does is it limits folks who have been in the United States, unless they're US citizens who want to enter Canada and make a refugee claim. It limits who's able to make a refugee claim. And the safe third country is a huge topic, so we're not going to extensively get into it. But what we're going to focus on is things that will now be different since C12 has passed. So essentially, there are exemptions or ways to sort of ways that people are able to make claims despite the safe third country agreement. And so one of those ways is for folks who do irregular border crossings. So usually when you enter a country, you show up at the port of entry and you speak to a CBSA officer if you're coming into Canada. And so since um, since there's barriers to making a refugee claim if you're coming from the US, to get around this, one thing that people have been able to do in the past is enter irregularly. So you don't enter through a port of entry. And then if you stayed in Canada for 14 days, you could then make a refugee claim. However, now people who do this will be found ineligible to make refugee claims, and they will also be put into the PRA system. So it's another group of people who aren't able to access the Refugee Protection Division and who will be reliant on the PRA process. There is another exemption to the Safe Third that has to do with if you have family in Canada, and Erin's going to talk about that.
Yes. So the other one that is the other exemption to the Safe Third um, that is impacted by this new law is when families come to a port of entry together and make a claim at the border. Okay, so um, this in the past was previously allowed because um, if a family arrived at a port of entry together and only one family member has an anchor relative, so that's an individual that's listed on the slide here, then they could make a claim for protection. That family member would be processed first and immediately referred to the IRB. And then the rest of the family, right there at the port of entry, would be allowed to make a claim using that family member as their anchor relative. So I'll just give you an example. It can be a bit confusing, but basically, say a mother, a father, and a child come to the port of entry together, and that mother has a niece in Canada. That means that only the mother can rely on that niece as an anchor relative because the niece doesn't have the requisite relationship to the father or the child to allow her to be the anchor relative for them. So what they would do at the port of entry is that the mother would use the niece as the anchor relative, immediately get her referral to the Immigration and Refugee Board, and then the father and the child could come in using the mother as their anchor relative. The change now is that the new legislation, C12, introduced a gap in time before someone is referred to the IRB. We don't know how long this gap is, but we are hearing it could be up to 6 months. So this means that that first family member can still use the anchor relative. So in this example, the mother can still come in and say, I have a niece in Canada. I am eligible to make a claim. But there's a period of time that the rest of her family would have to wait before they can come and make a claim using the mother as the anchor relative. If a family is thinking about coming to the port of entry together to use this anchor relative exemption, and there's a situation like this that applies, where the anchor relative is related to one family member but not the others, it's very important to get legal advice in advance about how to do this strategically, especially because of detention practices in the United States.
So I think it can be helpful to think of it as though it's a chain. So the anchor is one chain in Canada, and it used to be that family members could all clip onto that chain. And now it is that only the one family member, so in Erin's example, there's a niece and her aunt, the mother in this family can clip on, but now her spouse and her son, say, can't clip on in the same way. So instead of like forming a continuous chain, there's a break in time before that chain can be made. If case anyone's a visual learner.
Thank you. Yeah, that's helpful. A helpful way of thinking about it. And all that to say, there are some anchor relatives that could be used for various family members. So, say a mother comes with her child, that mother's mother could be used for both the mother and the child because they would be the mother of that claimant, but also the grandmother of her child. There are just certain scenarios where you would need to rely on that chain, um, and you would want to think about coming together and how to do that at the port of entry safely.
Yeah, so broadly, those are the changes to the safe third country that, or that's the impacts of Bill C12 on the safe third country. And I think that that is the end
Right.
of our slideshow.
So, really, really harsh changes that have come into place. And if you yourself or, other people who are caught up with these changes, as we've said, it's very important that you don't just do something without seeking proper advice as to whether or not it's right for you. The law is very, very complex. It is, it's still changing. There are a lot of new rules that are coming out. And by the way, anyone who has signed up for this webinar, we are going to put you on our list of people who will receive news on immigration law as they come out as well. And certainly if don't like it, then you can unsubscribe. But there's no other way for us to really let you know about news on immigration, which will happen all the time. In fact, we're going to send out a news blast on changes that are coming out for express entry sometime today as well. So if you want, we also are quite active on social media. So feel free to, follow us on there. If you would like to have a consultation with one of our lawyers at the firm, please email us. Let us know you've come to this webinar, and we will give you a discount for the consultation. All right. And so we have some time right now to go through some questions. We already have some questions posted on the Q&A. So we're going to go through that. And if you have questions yourself, you haven't posted, put them in the Q&A on the bottom of your screen. Okay. We're going to be answering general questions. This is a form which is recorded, and we're not going to be talking about specific situations for your own personal situation. But if you have a general question, we're going to do our best to answer them. All right. So let's get started. Katan, I'm going to have you answer the first question. This person asks, does it make a difference how they entered Canada after June 2020, or what status they had? I'm wondering, for example, someone in Canada with temporary status going back home, and something happens that makes them seek refuge and then come back to Canada for for example.
Yeah, so I would say the exception would be I'm going to exclude anyone who's caught by the safe third country, as we were talking about, because that is a different situation. But say that you had valid status, something happened back home, you will still be caught by C12. So if you answered yes to all of the things in the decision tree when you go to make your claim, unfortunately, one of the really, I think, problematic and honestly quite shameful things about this law is that it doesn't take it fails to account for how things can change at home or how things can change in person. Like, for example, for if you have a study permit and you enter Canada, and then in Canada you realize that you're queer or you're trans, that is a common reason that people will make a refugee claim after a year of being in Canada because, they're coming to terms with their own identity. And now these people are being caught under C12, and it's incredibly problematic. And the same as if, yeah, there's situations changing in your home country that now you're in danger when you wouldn't have been when you first entered Canada, or maybe when you came to Canada for a vacation in 2022. So unfortunately, the blanket way they have passed this law has created a highly problematic situation for many people. And yeah, Erin, I don't know if you have anything you want to add to that, but that's my
Yeah, no, I completely agree. I think that pretty much covers it. Just basically it comes down to the dates, unfortunately, and they're not leaving room to account for actual human factors and what's actually happening on the ground um, in different countries or in someone's mind and what's happening to a person's life. So yeah, I would just agree that this is um, one of the biggest issues that we take with this new legislation.
Okay. Next question, Aaron. Just to clarify, let's say someone entered Canada on April 1st, 2023, and they submitted their claim on February 2025. They are still eligible because their claim was submitted before June 3rd, 2025.
Yes. Okay. I'm just thinking about those dates, but yes, that is correct. You always have to go back to that sort of decision tree, but because the claim was submitted before the June 3rd, 2025 date, they would be fine.
All right. Katan, does CBSA have to tell the claimant that they can apply for PRA and give them the application? This person could not find the application online.
Yeah, so that's exactly it, is you can't initiate it yourself. And what happens is you are called in to an interview with CBSA, and they will physically tell you, like they'll physically give you the forms. You can still apply online later, but they have to say, we are now serving you PRA. You can't just start the PRA process. I will say at this point, we don't know what if there's going to be a big change in procedure that follows this law, but that is how the process system has functioned in the past, and that is how it will continue to function for now, which is why we'll have to see if they change their procedures, because obviously having people come in and serving everyone PRA is also going to be labor intensive for CBSA. And so we'll see if there's a change in the future. But for now, yes, you have to wait until you hear from them, and they are the ones who start the PRA process.
I think they're doing whatever they can to discourage people from making refugee claims, and they're just making everything quite difficult for people these days.
Yeah.
Okay, so next question. Is there any chance the government might review the June 3rd date and provide an extension if someone submitted the refugee claim just 22 days after the June 3rd deadline?
Okay, so I don't see that happening. There's always a chance that, there's uh, this legislation is subject to litigation and things change in terms of the details of the bill. But that the June 3rd, 2025 date comes from the date that the legislation was introduced. And as far as we've seen, they're not budging on that, and that seems to be the date that they're going with.
This bill has been debated, and many refugee lawyers, many nonprofit organizations, many members of parliament have talked about how this will adversely impact so many people, and the government has not budged. And now that they have a majority government, with this bill passed, and so the government is, I don't think, has any inclination to change this. As Erin has said, there will be litigation, so maybe, but that's going to take a long time if it's successful. Now, this person has also asked, what about then? Can I just withdraw the application?
It's always possible to withdraw an application, and I see there are a couple of questions on that in the chat, but I would say that that's something that you would definitely want to speak to a lawyer about. It's very case specific, and not something we could really get
And
into here.
yeah, and especially if you withdraw, it doesn't necessarily mean yet that you reverse all of the consequences as well.
Exactly.
You still have lost your temporary status. And so there's this is a road of no return when you file a refugee claim. And I can't emphasize that enough. There's no return from making the refugee claim. Later on, even if you change your mind, it doesn't matter. You've gone down that road already. Okay. All right. Katan, for applicants from Afghanistan, when should they apply for agency, before or after their refugee claim, knowing that their claim is ineligible?
So it would be, sorry, in this circumstance, the question, the person from Afghanistan has not already made a claim, I'm assuming.
Let's just say they haven't.
So since the person's from Afghanistan, they could apply for an agency without making a refugee claim. Um, there would be lots of factors to consider in those circumstances. So Um, if they make a refugee claim and are found ineligible, they could then they could then apply for an agency after that, and they would have access to interim federal health care in the meantime, which is the type of health care that refugee claimants can get access to. And also, it's going to be as accessible to refugee claimants who are ineligible to make claims while they wait for a PRA. So it would be, in the example of someone from Afghanistan who hasn't already made a claim, I would recommend talking to a lawyer about their specific circumstances, but since they won't be removed, they could do it before making a claim or after making a claim, depending on their circumstances and how it would also depend on their current status in Canada and how they have access to that status, I would say.
See, you see the word that they keep saying? Depends, 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 okay? So really, so we're not gonna answer for a person specifically. Everything depends on a person's own circumstances. Okay, next question. For international students who make refugee claims, if they are ineligible to submit their claim, will their study permit be canceled or can they continue studying? Now, this is a very interesting question because there's a difference between the cancellation of their study permit, which I believe does not happen right now until their removal order becomes enforceable, although the government could just cancel a temporary residence, any document they want right now. But it doesn't automatically get canceled. However, the temporary status is affected. So, if they are, trying to be eligible for provincial nomination or express entry, that's affected. But I believe that they might still be able to study if their study permit itself has not been canceled. Okay. All right. Next question. If your refugee claim is refused, how long does it take to receive a removal order? Can I still continue working under refugee work permit? Erin, would you be able to answer that?
Okay, yes. So if you make a claim and it's refused, your removal order would come into force immediately. So at that time, you would technically need to leave Canada. You would no longer be able to work under the refugee work permit.
Okay. What kind of response can one give the immigration if the entry was after August 2022? What ways should we go about the claim if it's not eligible for a court hearing anymore? Can someone appeal if there's no hearing?
So, sorry, they're
I
asking if
think a lot
they,
of these questions were answered in the first part of the session. But I think people are just wondering, this person is just wondering if it's ineligible. If they made a claim and it's ineligible, now what do they do? Uh,
if you've made a claim and if you already made a claim, you're found ineligible, you are in sort of a period of limbo now. You're waiting. If you already have a refugee work permit, for example, you can keep working with that work permit, but now you're waiting for the CVSA to initiate your PRA. So, people who have already filed their claims, people are getting letters from CVSA which say, or they're getting letters that say they're no longer eligible. And so you are now in a group of people who are waiting to be served PRA. And while you wait, you can keep working or doing what you're doing now, but you're waiting for the PRA process. And then once the PRA is served to you, as Erin set out, you have those timelines to get your forms in and then to get your evidence and your submissions in. And then um, you'll be waiting for a decision. And if your PRA decision is positive, you become a protected person. In most circumstances, there's an exception, but it applies to a small number of people. But you'll become a protected person. And then, just like you would with a refugee claim, and you can then apply for permanent residence. If your PRA is refused, as Erin was saying, your only recourse is to apply to judicially review it. And during that period, you actually, unfortunately, can also be removed. You don't automatically get to stay here while a court decides if your PRA decision was reasonable. And so then you would have to look at doing what's called a stay of removal, which would definitely be something you would want to talk to a lawyer about because they're quite complicated processes where you ask a court to not remove you while you wait for something else to happen.
Okay, so Erin, in practice, how high is the evidentiary bar in PRAs compared to IRB hearings?
Okay, that's a good question. It's not necessarily different in that you still need to provide evidence to support your claim, the risk that you're trying to say that you face or the persecution you're facing. But it's slightly different in that with the refugee claim, as we said, you do get a chance to actually speak to a human about what has happened to you, and you can rely more on emotions and like appealing to an actual human being, whereas the actual evidence can play maybe more of a role in the PRA, only in the sense that you don't get that chance to speak about it. So the officer is just looking at these documents. They're also reading submissions from the lawyer, and the lawyer is also trying to appeal to them using language, but it can be quite different when it's in writing versus being face to face with a claimant. Um, and just on that, I would add that statistically, the refusal rate is higher with PRAs than with refugee claims. So it is important to have very strong evidence with a PRA.
And sometimes they do even have PRA interviews, but the PRA interviews are very different than speaking. You're speaking to an immigration officer compared to a board member. Just to give you an idea, the approval rates, as Erin has said, for PRAs are around 2 to 5% for approval. Now, in the past, this was because, people had the refugee hearings to go to. Perhaps the approval rates might rise a little bit, but still, compared to the process for refugee hearings, PRAs are notorious for having very, very low approval rates. Okay, Katan, if someone is waiting for the PRA, can they apply for things like spousal sponsorship? And does that actually help them stay in Canada?
So again, I'm going to say it really depends on the person's circumstances. If that person is in a genuine spousal relationship, they can apply for a spousal while they wait for the PRA. However, unfortunately, like as Liz said, like the refugee process, once you're in that pathway, all interactions with immigration will be impacted by that. So if you're someone who's waiting for your PRA and you're also doing a spousal, you might have an officer who's more suspicious of the spousal because they might suspect that you're using your spouse as a way to stay in Canada um, while you wait for a PRA. So you might need more evidence about genuineness of the relationship and things like that. And it's definitely something you want to talk to a lawyer about, but you're not prevented from initiating that application and when you have a genuine relationship, but it might be more complicated. And I would definitely recommend talking to a lawyer about it.
All right, Erin, does Bill C-12 allow individuals without status since before 2020 to access the refugee claim process?
Okay. I would say again, it depends. I would need more information on, entry and entry dates to Canada. Like if the, but I think that from reading this, it seems like if someone has no status since before 2020, it's most likely that they haven't entered after that 2020 date. So they would still be able to make the claim. I would just maybe advise, again, talking to a lawyer, but the specific facts, not having all the information in front of me. But it seems in that case like it would very likely be that you could still make a claim.
Okay, Katan, if I came in as a student and then applied for a refugee claim, can I still withdraw the claim and just go back to school?
So you can withdraw your claim, but you can't go back to just being a student. It's as Liz said, once you've made the refugee claim, you have you've set yourself down this path. And so it impacts your ability to access temporary status, and you can't just make it go away like it never happened. Um, yeah.
Yeah. So, for those of you who are caught in situations like that, it's not that it's completely hopeless, but we do need to make very, very careful decisions in your circumstances as to what exactly you can do. And it's a very different sort of analysis than someone who is still an international student and has not made a refugee claim. All right. And final question is, does our firm do co-counseling? That's a very interesting question. I would say it depends on the circumstances of the case and whether or not it would work. But if that's something that you're thinking about doing, please reach out to us. We're happy to chat with you. All right, one last question. Aaron, this person came to Canada September 2021, went back to their home country November 2024, came back in January 2025, made a refugee claim in 2025, February 2025. Are they safe from this situation?
Okay, I'm gonna go through the tree. That's always what you have to go back to here. So, came to Canada in September 2021. That's after the June 24th, 2020 date. So, you have to go to the next question. Has more than a year passed since that date? Because the clock starts ticking on that entry. September 2020, 2021. The answer is yes. More than 1 year has passed since then. Did you submit the refugee claim on or after June 3rd, 2025? In this case, applied for refugee in February 2025, so you would be okay.
Okay, excellent. Excellent. All right, everyone. Thank you so much for participating. Thank you so much for your wonderful questions. We're here for you. I know this legislation can be devastating to so many people. But you know what? If you're here, maybe there's still hope. Do let us know and we'll try to figure it out with you. All right. Take care, everyone. Okay.
Thanks, everyone.
Thank you.